I was muted. Can you hear me now? Hello and welcome to another episode of Virtual Legality, everyone. Thank you so much for being here this morning. I am Hoeg, your host here of the Hoeg Law business law firm of Northville, Michigan, and hopefully we can have a good time today with a microphone that actually transmits my voice through the magic of technology and into your computer screens or phone devices or whatever else you're watching on. I'm very excited about this particular episode because we're going to be talking about some interesting things like constitutional law, what Congress can and can't do, social media platforms like TikTok, and we may even have a guest or two on this particular video. So thank you so much for being here. I'm sorry for the muting a little bit at the front end. Tech issues are always tech issues, but thank you for bearing with me, and we're going to get right into it very, very shortly as we do in Virtual Legality. So just hang on one second as we pull up some various screens here and get started. And before we do get into the law aspect of this, I did want to call out a special member of the community. If you've been here with us in Virtual Legality or on Hangouts and Headlines or Lawyers and Dragons for a while, you may know the name Shareen. She was a constant figure in our community. She was a mod for Legal Bites, Alita's channel that is currently covering the Karen Reed trial. And unfortunately, in the last couple of days, she passed away. And I wanted to make sure that we acknowledged her because when I got out of the hospital after my stroke and I was finally able to get back on social media and my wife gave me my phone back and all those good things, one of the things that I saw first when I turned on my social media was a direct message from Shareen the night of my stroke that said, I know you're not going to see this for a long time, but I want you to know that we're all supporting you and we all love you. And we're looking forward to you coming back and talking with us all in Virtual Legality. And she was such a constant support, and she sent mail and DMs to both me and my wife during that period and even before, when we were going through less dramatic but still dramatic times on YouTube. And the world is worse off without her, and I hope her family is getting through this, because I really feel bad when anything like this happens. And certainly she was a light in this community, and I know in so many other communities on YouTube and social media in general. So you will be missed, Shareen. And with that said, I don't want to belabor the point. I know you wouldn't if you were watching either, Shareen. So let's get into some of this TikTok stuff. TikTok challenges U.S. ban in court, calling it unconstitutional, says NPR. And indeed they do. I like this article because it's pretty much straight to the point on this stuff, and I thought it would be a good jumping off point for us to discuss what's happening here. Before we get into the weeds with statutes and lawsuits and some of the stuff we like to do here in Virtual Legality. So before we do that, TikTok and its parent company on Tuesday filed a legal challenge against the United States over a law that President Biden signed last month outlawing the app nationwide unless it finds a buyer within a year. It's actually 9 months with a potential 3-month extension if the president finds that a sale is moving forward. Banning TikTok is so obviously unconstitutional, says TikTok, that even the act sponsors recognize that reality and therefore have tried mightily to depict the law not as a ban at all, but merely a regulation of TikTok's ownership, according to the filing. The law, passed through Congress at lightning speed, which caught many inside TikTok off guard, is intended to force TikTok to be sold to a non-Chinese company in 9 months with the possibility of a 3-month extension, as we just mentioned, if a possible sale is in play. Now, notably, NPR here doesn't source passed through Congress at lightning speed, but it certainly seemed to come fast. And they also don't source, which caught many inside TikTok off guard. But you can certainly imagine that that was, in fact, the case, because TikTok has been operating on the assumption that the U.S. government might move against them at any time since the time when then President Trump, tried to ban TikTok from the United States, or at least its ownership by ByteDance, its parent company, through executive order back when he was still president. Yet lawyers for TikTok say the law offers the company a false choice, since fully divesting from its parent company ByteDance is simply not possible. Not commercially, not technologically, not legally, and certainly not on the 270-day timeline required by the Act. Now, as a mergers and acquisitions lawyer, I can tell you that 9 months actually is a pretty speedy timeline, even for a small company with a fairly knowable set of assets and liabilities and understandings that wants to sell, a motivated seller. So 270 days really is a short period of time for a massive technology transfer, and certainly one with parameters surrounding it that would not be self-selected by either the buyer or the seller, like how the algorithm needs to change hands, what code needs to change hands. We'll see that discussed in TikTok's lawsuit in just a minute. But I certainly think while this is maybe a overstatement in part by ByteDance and TikTok, it isn't certainly an incorrect or inaccurate one to say that this would be a very accelerated process to get this done on that kind of timeline. Now, this article then goes and quotes a few legal experts here. Anupam Chander, a law professor at Georgetown University who specializes in technology regulations, said if TikTok loses this legal fight, it will likely shut down in the US. And I tend to agree. The problem for TikTok is that they have a parent company that has these obligations in China, but they're trying to live by free speech rules by the United States. The question is whether American courts will believe that's even possible. And I disagree with that analysis to some extent. I think this will be read more on the black letter law of whether or not Congress can make these kinds of determinations for national security or other reasons. And we'll see why that is at issue in just a minute. But I don't think the court system is either equipped or desirous of adjudicating whether or not this particular company can abide by multiple jurisdiction sets of speech rules and regulations. The real question is whether or not Congress can ban a platform that operates with a certain amount of Chinese or other country ownership. And that is going to be an open question, which we will see in just a sec. TikTok says law is based on speculative and analytically flawed concerns. Here's one place where I think TikTok goes a little bit far in their complaints. Lawmakers in Washington have long been suspicious of TikTok, fearing its Chinese owner could use the popular app to spy on Americans or spread dangerous disinformation. But in the company's legal petition, lawyers for TikTok say invoking national security does not give the government a free pass to violate the First Amendment. Especially, TikTok argues, when no public evidence has been presented of the Chinese government using the app as a weapon against Americans. Now, when I say that go a little bit far here, is they are absolutely correct that national security as a statement from the Congress or the government or elsewise does not get them out of the application of the First Amendment or any of the Bill of Rights or any other restriction that the government has on the exertion of its powers. But the fact that Congress didn't include recitals in its statute that says this is why we're angry at TikTok, this is why we think it's a problem, or has shared public information that's not otherwise classified, doesn't limit their ability to pass a law like this, right? They could come to court and say, sure, we didn't say it in advance, we didn't put it in the statute, but here's the evidence, here's why we acted the way we did. And the reason that will come up is because whenever we talk about an infringement of a fundamental right, like the First Amendment, freedom of speech, then one of the things that a court will have to determine is whether or not the government had a compelling interest in infringing on that particular right. And you might say that all of the Bill of Rights says Congress shall not otherwise infringe, and that this is a strange thing to be saying, Rick, that the court will adjudicate whether or not there was a compelling government interest. But court jurisprudence has essentially allowed certain government infringements, regardless of the text of the Constitution, if the government can make a strong enough case. Now, that being said, that strong case has to be really strong. The policies that they put in place to do the infringement have to be narrowly tailored to that specifically compelling interest. And we call that strict scrutiny, the courts do, when they evaluate a statute and whether or not it should be deemed constitutional for these purposes. And strict scrutiny, for the most part, is a level of scrutiny that the court applies, and statutes fall when they do apply that level of scrutiny, right? So one of the things that will happen in this case is that TikTok will try to say that this is a direct infringement of our First Amendment rights, and that requires strict scrutiny of the courts because they know that the courts generally strike laws down when strict scrutiny is applied. And Congress will try to say, no, it's not a direct infringement of their First Amendment rights. It's a regulatory concern. It's an economics regulation. We have national security at play here, so this should have a lesser level of scrutiny applied to it. And at lesser levels, the court will very often defer to Congress's overall general authority to pass legislation within the United States. According to the filing, the law is based on speculative and analytically flawed concerns about data security and content manipulation, concerns that, even if grounded in fact, could be addressed through far less restrictive and more narrowly tailored means. And that's that other aspect of strict scrutiny that we just talked about, right? Even if you have a compelling government interest, under the strict scrutiny level of evaluation by the courts, that compelling interest, the answer to the compelling interest, has to be narrowly tailored to addressing whatever your interest is. And here TikTok says, okay, not only do they not have a compelling interest or they haven't shared it with us, but if they did, banning us from operating within their jurisdiction is way too big of an answer. It's a shotgun when a scalpel will do. Constitutional scholars say there are a few ways for the government to restrict speech in a way that would survive a legal challenge. One of those ways is if the government can demonstrate a national security risk, insofar as it would be a compelling state interest, yes. Also key, legal experts say, is the government showing that speech suppression was the least restrictive option on the table. And that's a paragraph that kind of takes what we just talked about with respect to strict scrutiny and makes it a little bit more ambiguous than it needs to be. But those are both true, right? They need to show a compelling interest, and they need to show that it was tailored to that compelling interest. TikTok said Congress ignored less restrictive ways. We'll see that in their lawsuit. And also said it's not plausible for them to divest. You can't really create a TikTok US while having a different company manage TikTok Canada, says their expert. What you're doing essentially is creating a rival between two TikToks. It may be better to take your marbles out of the United States and hope to make money outside of the US rather than sell it at a fire sale price. And this actually says part of the quiet part that TikTok doesn't say so much in their lawsuit, which is to say it's not that it's impossible for TikTok to sell. It's that the product that they would be selling, TikTok US, is so devalued from what the asset would be in an operational ongoing concern that they didn't want to sell it. They don't want to sell it in that form because they are evaporating the equity that they hold in this thing that they've built. At least that's their argument, right? And I don't pretend to be a financial analyst or one that knows the value of TikTok on its own versus the value of a US-based TikTok only. But that is certainly part of the argument that they make when they say that it's not plausible for them to divest. Now, in point of fact, I don't think they actually have to win that particular argument that it's not plausible for them to divest, because I think that the divestiture provision, the ability for someone to get outside the parameters of this law that the United States just passed by selling off all their interest in a company, doesn't make it a non-penalty, right? It's not that you could sell and you didn't, and so now they can bring the full force of the statute against you. The fact that the sale requirement is made is the penalty in and of itself. So there's an old precept in U.S. jurisprudence that says the power to tax is the power to destroy. And I've always liked that particular line, not because I like to talk about taxes or destruction necessarily, but because it is a notion in U.S. jurisprudence that I think is very true. Once you have the authority to really put pain points on somebody operating within your jurisdiction, whether that's the United States or somewhere else, you essentially have the power to make it unpalatable in its entirety to operate within that jurisdiction. So when they talk about they can't sell and it's a illusory kind of out, that's helpful for them from a rhetorical standpoint, but I don't think it's necessary from a legal standpoint. Even if they could sell and it wouldn't scuttle their entire business operations, it's still not something that they should have to do if the court finds that this is an overreach by the U.S. government. Congress has never before passed legislation that could outright ban a wildly popular social media app, a gesture the U.S. government has criticized authoritarian nations for doing. And here's the NPR editorializing a little bit, interestingly, against the U.S. government's position. In this case, however, lawmakers have called the app a spy balloon on your phone, emphasizing how the Chinese government could gain access to the personal data of U.S. citizens. Yet the fears so far remain hypothetical. There is no publicly available example of the Chinese government attempting to use TikTok as an espionage or data collection tool. And here I'm going to sit here and say, we don't know what we don't know with respect to classified intelligence, right? We don't know what Congress is acting on with respect to some of the information that they might have. So only we can evaluate this as TikTok has suggested with what is publicly available. But we do have to at least reserve for the possibility that if this were to go to trial, that Congress could show legitimate concerns over national security or personal data of the United States going to places where they really don't want it to go. And if they can show that, then their case is going to be much stronger than it looks right this second. TikTok, for its part, says it has invested $2 billion on a plan dubbed Project Texas to separate its U.S. operations from its Chinese parent company. It deleted all of Americans' data from foreign servers and relocated all of the data to servers on U.S. soil, overseen by the Austin-based tech company Oracle. While the plan was intended to build trust with the U.S., lawmakers and users, reports surfaced showing that data was still moving between staff in California and Beijing. In the filing on Tuesday, TikTok said it submitted an agreement to the Committee on Foreign Investment in the United States, or CFIUS, to lawyers, which has been probing the app for 5 years, that would allow the U.S. to suspend TikTok if it violated terms set forth in a national security plan. But lawyers for TikTok say the deal was swept aside in favor of the politically expedient and punitive approach the petition states. I don't know if you need the lawyers say and petition states in the same sentence, but I am not the journalist here. Despite the new law giving TikTok the ultimatum of selling or being shut down, there are many questions around how the app could even be bought by another company or group of investors. Former Treasury Secretary Steven Mnuchin told NPR on Monday He is planning to assemble a group of investors to try to purchase TikTok without the app's algorithm. Munchen, who declined to answer additional questions, said in between sessions at the Milken Institute Global Conference in Los Angeles that the proposal to buy the app is still in the works, but he would not say when it would be formally submitted. And here was where we get real politics cynical here in Virtual Legality, right? I don't know Stephen Munchen. I don't know the conversations that were had at Congress behind the scenes with respect to this ban. But certainly when you see that the former Treasury Secretary is trying to put an investor group together to buy a U.S. TikTok with or without the algorithm at potentially a lower price than the operational ongoing concern would be, it starts to look a little bit like a shakedown, right? And you might hate TikTok. You might think that it's a major risk because of the Chinese connection of ownership through TikTok. But this starts to look like a U.S. government or former U.S. government official shakedown to a company's value. And I think that's a problem, even just optically, when you're considering how this thing looks. And I think that might wind up coming up in any possible court case that happens here. Despite the new law in the U.S., ByteDance says it does not intend to let go of the service. Furthermore, winning the support of China would be necessary, and officials in Beijing are adamantly against any forced sale, as you would imagine. In 2020, amid the Trump administration's clampdown on the app, China added content recommendation algorithms to its export control list, effectively adding new regulations over how TikTok's all-powerful algorithm could ever be sold. ByteDance, not TikTok, developed and controls the algorithm that determines what millions see on the app every day. And here's where things get a little bit confusing because TikTok is just a platform. TikTok's a product, right? TikTok isn't its own separate thing. There is a TikTok Inc. that operates certain aspects of the platform. But this is an area where TikTok is going to complain in its lawsuit that Congress did not properly identify the various bodies that it's trying to penalize because they just used the words TikTok rather than an actual operating entity. The technology has become the envy of Silicon Valley, and no U.S. tech company has been able to dislodge TikTok's firm hold on the short-form video market. Experts say key to its success is its highly engaging and hyper-personalized video ranking algorithm. And here's where I say I don't use TikTok. I use Twitter, and their For You tab is god-awful. So certainly some of these platforms are having trouble actually having a For You algorithm that works presumably as well as TikTok does. But some of you in the comments might be better able to speak to the TikTok experience and why it is as popular as it is. The algorithm, which involves millions of lines of software code developed by thousands of engineers over many years, cannot be easily transferred to the US, even if China did allow it, TikTok's challenge states. And they go a little bit further in talking about that. We will see that in their lawsuit. But that's the overview of what's happening in this particular state of affairs. And we're going to talk about it more specifically as we do here in Virtual Legality with the primary source material. Before we do, I also wanted to mention that if you haven't seen it, David Grace, who is our game master in Lawyers and Dragons, has been doing more topical videos on his channel, Prototopics on YouTube. And one of those topical videos that should go live maybe today, tomorrow, I don't know when exactly, is a conversation that David and I had on this specific issue, on an article talking about the TikTok ban and the TikTok challenge. And I highly recommend you check it out. I think it was a good conversation if and when it goes live. And hopefully David will pop in at some point so that we can talk about that and what he's doing with Prototopics on this video on the whole. But I wanted to make sure that that was mentioned because you should check it out when it goes live. I think it's a very good conversation, especially if you wind up liking this Virtual Legality conversation here. So with that said, let's look at this petition, which I have right in the middle, which is not terribly useful to us. But this is the lawsuit that TikTok Inc. and ByteDance Limited have brought against the United States, or more specifically, Merrick Garland as the Attorney General of the United States. A petition for review of the constitutionality of the Protecting Americans from Foreign Adversary Controlled Applications Act, which is a mouthful. Congress has taken the unprecedented step of expressly singling out and banning TikTok, a vibrant online forum for protected speech and expression used by 170 million Americans to create, share, and view videos over the internet. And obviously, this section of the lawsuit is going to be very positive about what TikTok is doing, and it's going to be very kind of politically editorializing about how TikTok feels about this, as we see at the top of all these lawsuits. That law, the Protecting Americans from Foreign Adversary Controlled Applications Act, is unconstitutional. Banning TikTok is so obviously unconstitutional, in fact, that even the Act's sponsors recognize that reality and therefore have tried mightily to depict the law not as a ban at all, but merely a regulation of TikTok's ownership. Right? If you actually go and you look at how this law was passed, it was passed under the power of Congress under the Commerce Clause in the Constitution, which gives Congress the power to pass laws governing and regulating interstate commerce among the various states and international bodies in the United States and around the globe. So they say, well, look, TikTok is commerce. You make money. It's a commercial endeavor. We can control it. But all the rest of the restrictions that come into play in the Constitution do happen, like the First Amendment. And that's where TikTok wants to wind up. They want to say, well, in this particular case, you are not just banning a random economic product. You're banning something that is fundamental to the expression of speech, both by us, TikTok, and by the users of our platform. Banning TikTok is so obviously unconstitutional. They say that they can barely pick how they're going to argue against this, but there's a lot of ways that they find in their 70-page document. In reality, there is no choice to divest the company. The qualified divestiture demanded by the act to allow TikTok to continue operating in the United States is simply not possible. Of course, even if a qualified divestiture were feasible, the act would still be an extraordinary and unconstitutional assertion of power. If upheld, it would allow the government to decide that the company may no longer own and publish the innovative and unique speech platform it created. If Congress can do this, it can circumvent the First Amendment by invoking national security and ordering the publisher of any individual newspaper or website to sell to avoid being shut down. So here we see TikTok arguing kind of the slippery slope, right? If Congress can just declare national security with a neon sign and do anything it wants and violate the First Amendment, then TikTok is the first of your concerns, but not the last of your concerns, Your Honor. Congress can do this to anybody, and we very much don't want Congress doing this to newspapers or individual websites or those kinds of things. There are good reasons why Congress has never before enacted a law like this. Consistent with the First Amendment's guarantee of freedom of expression, the United States has long championed a free and open internet, and the Supreme Court has repeatedly recognized that speech conveyed over the internet fully qualifies for the First Amendment's protections. There's really no doubt about that. And consistent with the fundamental principles of fairness and equal treatment rooted in the Bill of Attainder Clause and the Fifth Amendment, Congress has never before crafted a two-tiered speech regime with one set of rules for one named platform and another set of rules for everyone else. So it's about time that we talk about Bill of Attainder, which is not a place where Bill lives. It's an old-timey phrase that described the ability of, at that point, the English common law justice system to pass laws that penalized upon death individuals by name without a separate finding of a violation of the law. This also goes along with the ex post facto law concept, which is naming something as illegal after the act took place. And the reason our Constitution says no bill of attainder or ex post facto law shall be passed is because those are both fundamentally unfair. They are against our notions of fairness and justice, right? To say you are so bad that we know without a trial, without due process, without going through our normal judicial procedure, that you are bad enough to be violative of this law that we passed. We say you can't steal cars. And also we know Rick Hoeg is a car thief. And so you can't steal cars, and Rick Hoeg is automatically a car thief that can be put in jail or have whatever other penalties are applied to a car thief upon him. Similarly, that you can't say in a law that you pass that it's generally applicable in this way, but also we know for a fact that this company is violating it beforehand, and so we're going to name them, and that's what a bill of attainder is. Supreme Court cases have given broad and generous meaning to the constitutional protections against bills of attainder by interpreting it to ban not only legislation imposing a death sentence, as the term was used at English common law, but also legislation that imposes other forms of punishment on specific persons without trial. And before we get too far into this, I do want to point out this is from the Constitution Annotated. This is a document that's been in publication for over 100 years. It was ordered by Congress to be created by the Librarian of Congress to compile and periodically update the Constitution Annotated to provide essential information to Congress and the public at large. So this is a good source of materials for how the Constitution has been interpreted over the long history of the country at this point. But it's also worth noting that this is the kind of thing that Congress should very well know. However, the court has emphasized that legislation does not violate the Bill of Attainder Clause simply because it places legal burdens on a specific individual or group. Rather, as discussed in more detail below, a Bill of Attainder must also inflict punishment. Another key feature of a Bill of Attainder is that it applies retroactively. The Supreme Court has held that the Bill of Attainder Clause does not apply to legislation that is intended to prevent future action rather than to punish past action. Overall, the Supreme Court's decisions suggest that the court has applied the Bill of Attainder Clause to prevent legislatures from circumventing the courts by punishing people without due process of law. And then we continue on. The Supreme Court applied the constitutional prohibitions on Bill of Attainder in a pair of Reconstruction-era cases, Ex parte Garland and Cummings versus Missouri. Garland concerned a federal statute, while Cummings involved a post-Civil War amendment to the Missouri Constitution. But both of the challenge provisions required persons engaged in certain professions to swear an oath that they had never been disloyal to the United States. In both cases, the court held that the effect of the challenge provisions was to punish a group of individuals who had been disloyal to the United States, and the punishment they faced was effective exclusion from the covered professions. So note, this isn't named individuals. This is a class of individuals that are being asked in order to get their license to practice whatever profession that they have never been disloyal to the United States, punishing them for having been disloyal in the case of the U.S. Civil War, which was recently concluded at that point in time. Based on the holding, the Supreme Court invalidated the provisions as unconstitutional bills of attainder. In Cummings, the court noted that the challenged state constitutional provisions did not expressly define any crimes or declare that any punishment shall be inflicted, but they produced the same result upon the parties against whom they are directed, as though the crimes were defined and the punishment was declared. So here, what's important to note is that because the bill of attainder rule is so easy to avoid, that Congress really isn't in the habit of naming companies or naming individuals because they know that that's not allowed under their constitutional powers, that the Supreme Court precedent on this topic actually goes beyond that to say, if this is something that is a class of people that's generally described, that you can take under advisement that they will be punished in a way that they don't deserve to be without due process of law. And so Congress can't pass a law like this one. And here we have David Grace. We just talked about your wonderful channel, Prototopics, David.
Wonderful channel. It's wonderful to be here. I'm sorry that I'm late, but happy to be here just in time. I was just starting my TikTok dance career.
I know it. And you've got that TikTok cadence down, right? If you have never watched David's channel, he does some of those cool videos where he edits himself in different clothes and looks at the camera from different angles and talks to himself, like I see when TikTok videos surface on Twitter. So I can't pretend to be the foremost understander of TikTok or other social media culture. But David, you seem to have your finger on the pulse.
I'd like to say it's gently inspired more from like old SNL than it is trying to keep up with TikTok of like the costume changes. But yes, the TikTokification of attention spans on social media is on the bleeding edge, and something we got to keep track of to keep user attention.
Well, there you go. And that's why,
challenge.
Folks, I'm in the business of making multiple hour-long legal deep dives because I am on the opposite of the bleeding edge. But we're happy to do it here in Virtual Legality. And David, you just came in time to talk about bills of attainder, which I know is one of your specialities and expertises, right?
Yes. Here at Law Muggle King University, that is what we focus on.
Yes. So we were just going into the fact that because the Constitution bars Congress from essentially naming and shaming people or institutions, Congress has, for the most part in United States history, avoided doing that by making things applicable only to classes or groups of people. In this case, right after the Civil War, requiring specific professionals to declare that they have never been disloyal to the United States, and if they can't, to not be allowed to practice their profession. And the Supreme Court held that, without the specific name and shame, to be a violation of the Bill of Attainder Clause, because Congress knew what it was doing and knew that these particular people would be unable to make that declaration. The provisions aimed at past acts and not future acts were intended to operate by depriving such persons of the right to hold certain offices and trusts and to pursue their ordinary and regular avocations. The court held that this deprivation constituted a punishment and that the purported option to avoid the restriction by swearing a loyalty oath did not make it less so. To make the enjoyment of a right dependent upon an impossible condition is equivalent to an absolute denial of the right under any condition, and such denial enforced for a past act is nothing less than punishment imposed for that act. Right. And the biggest issue that TikTok has with respect to the Bill of Attainder concept here is that because Congress didn't provide any context for why TikTok and ByteDance are specifically named in the statute, as we will see in just a minute, they don't actually have the tie bar to say this is what act they're trying to punish. Right. There isn't a loyalty oath kind of concept here. But in some ways, it's worse because TikTok and ByteDance are named without any indication of why. That's honestly a worse punishment, and that's what TikTok will argue in their particular lawsuit. In the 1946 case, United States versus Lovett, the Supreme Court struck down as a bill of attainder an appropriations bill cutting off the pay of certain named federal employees accused of being subversives. The court explained that the challenged legislation effectively declared specific persons guilty of the crime of subversive activities without the safeguards of a judicial trial. The legislation further permanently barred those persons from government service, which qualified as punishment of a most severe type. Similarly, in the 1965 case United States versus Brown, the court held that a federal statute making it a crime for a member of the Communist Party to serve as an officer of a labor union was a bill of attainder. The Brown court eschewed a rigid historical view of the bill of attainder clause, explaining that the clause was intended not as a narrow technical prohibition, but rather as an implementation of the separation of powers, a general safeguard against legislative exercise of the judicial function, or more simply, trial by legislature, right? So thinking about this from the U.S. kind of civic standpoint, the legislature is supposed to write laws of general applicability, and then law enforcement, the executive branch or more down on the street law enforcement, is supposed to bring potential cases as violations of that law of general applicability before the judicial branch. If Congress says this thing is illegal and we know this guy is guilty of that thing, then that is a potential problem under the Bill of Attainder clause. The court concluded that Congress had exceeded the authority granted it by the Constitution in enacting the challenge statute because rather than creating generally applicable rules for the courts to apply, the statute designated in no uncertain terms the persons who possess feared characteristics and therefore cannot hold union office without incurring criminal liability members of the Communist Party. So when we look at the law that we're about to look at right now, it's important to keep this kind of Bill of Attainder concept in mind, because in my opinion, even though the TikTok lawsuit is leading with kind of the First Amendment flavoring to their particular complaint against this law, where their actual legal argument lies is on a violation of the Bill of Attainder provision of the Constitution. So let's take a look at this law and see how it is written. So we've got the Protecting Americans from Foreign Adversary Controlled Applications Act, which I should point out is an act that is baked into a much larger set of various political things that are happening in what I think is like the Peace Through Strength Act, which is as Americanly named as can possibly be. But we've got this particular act regarding TikTok baked into that much longer document. So as we look at this, I think it's important to note we've got a prohibition of foreign adversary controlled applications. It shall be unlawful for an entity to essentially help a foreign adversary controlled application by carrying out in the United States any of the following: providing services to or providing internet hosting services for that particular foreign adversary controlled application, which of course poses the question to anybody reading this, what the heck is a foreign adversary controlled application? So we have to go past the exemption for selling it within the 9-month period down to the foreign adversary controlled application, which is a website, desktop application, mobile application, or augmented or immersive technology application that is operated directly or indirectly by any of ByteDance Limited, TikTok, a subsidiary of or a successor to ByteDance or TikTok that is controlled by a foreign adversary. We'll come back to that in just a second. Or an entity owned or controlled directly or indirectly by an entity identified in any of those, or a covered company that is controlled by a foreign adversary and that is determined by the president to present a significant threat to the national security of the United States following the issuance of a public notice proposing such determination and a public report to Congress submitted not less than 30 days before such determination. So you can see what ByteDance and TikTok are getting at here. This part, the covered company part, is the real law, right? The foreign adversary controlled application is an application operated by a company that is controlled by a foreign adversary that is determined by the president to present a significant threat to the national security of the United States following things like a public notice and a report to Congress, or it's anything operated by ByteDance or TikTok. And that, to me, as a lawyer that learned about bills of attainder long ago in law school, looks very much to me like a bill of attainder. And usually Congress is good enough to not name these things. And in fact, when David asked me to research this for purposes of the conversation that we had and will be showing on his channel, when I looked at this for the first time, I said, oh my God, they actually wrote the names in the statute. This is like 1L issues of constitutional, right? This is what you avoid pretty easily. There should be somebody in the congressional offices saying, no, you can't name them that way. You can absolutely try to describe them so that they're the only ones that are included, which is part of what's difficult about writing statutes. But you can't just say anybody that is seen by the president as a threat to national security, or ByteDance or TikTok. And then we also note here that for a congressional statute, this is a pretty big foot fault itself. TikTok is not a separate entity, right? So any of ByteDance or TikTok, that's just a platform. And so one of the things that TikTok winds up saying in its lawsuit is, we assume Congress meant TikTok Inc. And so we're including them as a party here, but they're a wholly controlled subsidiary of ByteDance anyway, so they'd be included in the ByteDance owned piece, period. But we think this is a violation of our due process because every other company has this right here, and we don't get it. No matter what we operated, we could operate an ice cream stand platform, and it would be a foreign adversary controlled application, even though everything else needs to find a threat to the national security of the United States. And TikTok says that's not fair, Your Honor. And I'm inclined to agree with them. As somebody that doesn't use TikTok and doesn't have much at stake in this particular ban, I think that they've got a point when they say that, and they will be saying that for many, many paragraphs to come, many of which we will skip because it's a 70-page document. But I also wanted to point out one other foot fault that Congress has in this statute, which is this exclusion right here. The term covered company does not include an entity that operates a website, desktop application, mobile application, or augmented or immersive technology application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews, right? So remember, covered company is the main way that you get into, if you're not ByteDance or TikTok, this particular category of problems where you're banned from operating in the United States. But it does not include not just a platform that is primarily for the purpose of product or business reviews or travel information reviews, but any company that operates a website, desktop application, or augmented or immersive technology application whose primary purpose is to allow users to post product reviews. So as TikTok will point out in their lawsuit, and I don't know that I highlighted that section in particular when we get back to it, as TikTok points out in their lawsuit, this will allow specifically a foreign adversary controlled application to work in the United States if the company that creates that application also has a travel review application of some kind. And that's another violation of their due process rights, because ByteDance and TikTok can't do that and can't even specifically just do travel information reviews, because anything that they make is automatically a violation of this and automatically outlawed from being operative in the United States unless they sell within this 270-day period. And it's also worth noting that the original version of this bill had a 180-day period here, which would have been even more draconian than this 270 days. And the original bill didn't have this 90-day extension period. So you can see, if you look at these bills together, that Congress is trying to be a little bit more generous in the way that they've framed this particular exemption. They're trying to get it outside of this lawsuit land and make it more likely that TikTok just gets out, right? There's a certain notion, reading between the lines here, that Congress doesn't necessarily believe that this will pass constitutional scrutiny, but that if they give a big enough window and they make it attractive enough to TikTok, that maybe TikTok just says, we don't need this lawsuit, we'll just sell, this isn't worth our time or our trouble. I don't think that's going to happen in this particular case, but you can see that that could be some of the thought process that's happening. I think the bigger problem, of course, is naming ByteDance and TikTok completely separately from everyone else that they want this to apply to. And TikTok is rightly kind of upset about that in the lawsuit that we've taken a look at already, right? David, did that all make sense to you?
Well, so playing the other side of that, because it was a bipartisan vote in Congress, and it was like an overwhelming movement. But to do something that's sloppy, would there have been, is it actually not sloppy? Is there a way that you could look at it from their side of the argument that this was intentional for a reason and we will win because of that?
Well, I think that the strongest argument is that you aim it specifically at those people because you want it to hit them and nobody else. And the problem with statutes is that they can be over or under inclusive. But the reason you don't have bills of attainder is because you're not supposed to adjudicate someone as violative in advance on the legislative side. I think more importantly for that it happened so fast and was so overwhelmingly approved as part of this argument is that, let's say that it is unconstitutional. Let's say this is struck down by the courts. There's nothing really preventing Congress from taking another bite of the apple, from giving it another go and correcting whatever things the court identifies as problematic. So, right, if you're a TikTok fan and you're looking at the current state of politics in the United States and you say, well, Rick at Virtual Legality says that this could be a problem under constitutional jurisprudence, that's right. But Congress is still in charge of the legislature, is still in charge of the laws. They could amend this statute. They could write another one that just says they call it the complying with that moron judge that struck down the last law act. And they write it the way that the judge asks them to write it. So if there is still that kind of overwhelming desire to have TikTok removed from the United States or removed from ByteDance ownership and operate within the United States, then you would assume that this could be corrected by that same legislature in the future. But politics doesn't always work that way. right? It
Right.
could be when this goes down again in 9 months or 12 months, that the Congress has different feelings closer to an election than it did when it originally passed this, that separated out from this whole omnibus bill about national security, that it could be a different ball of wax for those particular congressional members that voted for it the first time. So if you're TikTok, it's still worth pursuing this. But yes, the real politic at the end of the day is when you pass like 300 to 90 or whatever that first vote was, you do have a worry that they're just going to change the words a little bit and try it again.
Right. So there really is no hope for TikTok, even if, in a lot of ways, even if this goes through and even if Congress says it's unconstitutional, they really could just reload the gun.
Well, Congress always has that option, right? And we see that a lot with respect to court decisions that Congress disagrees with. Court decision that says, well, you can't do this way, and Congress should have done it this way. Congress passes a new law the day after the court decision comes out. That's how Congress is supposed to operate and respond to these various things. So there's nothing really wrong with that in the legal process. Certainly, if you are kind of targeted like TikTok is, you're probably over this whole thing. And we can see that kind of in the tone of the first couple of paragraphs of this lawsuit. But I wanted to definitely frame out for folks what a bill of attainder is, why and how they're prohibited under the Constitution, because I think that's a very important part of this conversation. And honestly, it's not one that is talked about a lot because for the most part, Congress is usually smart enough to avoid naming and shaming people on an individual basis. So this is unusual. It's one of the reasons why I was really excited about talking about it with you, David, was that it's very rare that we get to use some of this precedent because for the most part, it's settled law. These are not things that are easy to have foot faults on in Congress. So yeah, I think it was too fast. I think it was so fast because there is that kind of bipartisan support for the notion that TikTok could be a very bad thing. But one of the things I've talked about a lot in virtual legality is the one thing that politicians of all stripes seem to be able to agree on is that social media, internet technologies, and tech companies in general are gathering enough power that they are a certain amount of threat to the political class on the whole, which is why you see Republican and Democrat agreement on this. This is why you see a story in TikTok where Trump tried to ban it when he was president, and now Biden is trying to ban it while he's president, right? Obviously, very two different sides of the political spectrum in the United States, but still see TikTok as a problem because why? They have so many eyeballs on them and they can control so much messaging that the politicians, I think, rightly look at that and say that's a threat to whatever type of messaging we want to put out there, or whatever type of thing we want to do with our political bodies.
I just wish that when it comes to having these hearings where they're asking questions of Zuckerberg and of ByteDance, the people asking questions, the congressmen, the senators, whoever it is, I just wish they knew what they were talking about. You know?
Yeah, you would.
Does TikTok connect to Wi-Fi? Why does TikTok connect to Wi-Fi? You don't know what you're talking about. Those are the wrong questions.
I am not a cat. Yes, it is roughly the I am not a cat level of inquiry here. And I've long talked to folks here in my community about the fact that one of the reasons I became a lawyer was that I watched the Senate hearings about Night Trap and Mortal Kombat back in the 90s and said to myself, somebody needs to get an understanding of statutes and lawmaking and video games and pop culture that is better served than these people that are on my TV screen that could otherwise ban things that I enjoy. So that's a part of the conversation, certainly, is that our political class is more of the older variety, as we know from our presidential candidates coming up, but also just across Congress on the whole, and that they tend to look at these things. And TikTok, I think, rightly says, basically, Congress is scared of the fact that there's some Chinese ownership of TikTok, and that's basically all they've told us. Congress enacted these extreme measures without a single legislative finding. Even the statements by individual members of Congress in a congressional committee report merely indicate concern about the hypothetical possibility that TikTok could be misused in the future without citing specific evidence. And again, I say TikTok goes a little far here because they don't have to cite that specific evidence in the statute. They can present that evidence as part of this legal challenge. But TikTok is right to say, hey, look, we're just operating here. They haven't told us anything. And if TikTok is in the right and that they're not, secretly taking your data and sending it to Beijing, then they're looking at this as a Congress that's going far beyond the pale. Now, if you think TikTok is actually a front for the Chinese Communist Party and they are sending that data, then this all looks like so much hand waving in and of itself, right? So Congress is going to have to essentially prove its case that there's a compelling state interest here at some point But even if they can, and the First Amendment versus national security is one of those areas where the court, it's unclear which way they would go, although there's often a deference to national security concerns for legislatures. That Bill of Attainder, the way that the statute is written, is probably the better argument as it stands right this second. Nor is there any indication that Congress considered any number of less restrictive alternatives, such as those that petitioners developed with the executive branch after government agencies began evaluating the security of U.S. user data and the risk of foreign government influence over the platform's content as far back as 2019. And that's when the Trump administration starts to ask about TikTok and Chinese ownership. As part of this engagement, petitioners being TikTok here, have voluntarily invested more than $2 billion to build a system of technological and governance protections, sometimes referred to as Project Texas, to help safeguard U.S. user data and the integrity of the U.S. TikTok platform against foreign government interference or influence. And we see this referenced in the NPR article that we started this video off with. We also noted that they said that there were reports that some data was still going from Texas to Beijing. So again, it's kind of a he said, she said between governments, between China and the United States, between TikTok and what it's doing publicly and what it might be doing privately. And that's worth noting because Congress could have a case here. As I said at the top of this video, we don't know what's classified. We don't know what we don't know on this. But as it stands right this second, it's a little bit unclear as to why Congress has otherwise labeled TikTok and ByteDance enemies of the state, quite literally. Congress tossed this tailored agreement aside, and we see this language that I highlighted in red as tailored because, as we said, strict scrutiny requires a narrowly tailored solution to a compelling state interest. And so they're saying, look, we've been talking with the executive branch, we've been talking with the U.S. government, we have been working on a narrowly tailored provision that would say, hey, look, if we actually steal data, if we actually do some bad thing that we can agree to as part of a national security arrangement, then you can do very bad things to us. But instead, they came in with the nuclear bomb approach rather than this narrow tailoring, and that, Your Honor, is why it should be seen as violative of the Constitution. In favor of the politically expedient and punitive approach of targeting for disfavor one publisher and speaker, TikTok Inc., one speech forum, TikTok, and that forum's ultimate owner, ByteDance Limited. Through the Act's two-tiered structure, Congress consciously eschewed responsible industry-wide regulation and betrayed its punitive and discriminatory purpose. Congress provided every other company, however serious a threat to national security it might pose, paths to avoiding a ban, excluding only TikTok and ByteDance Limited. Indeed, for any other company's application to be banned, Congress mandated notice and a public report describing the specific national security concern accompanied by supporting classified evidence. For petitioners only, however, there is no statement of reasons and no supporting evidence with any discussion of the justifications for a ban occurring only behind closed doors. Congress must abide by the dictates of the Constitution, even when it claims to be protecting against national security risks. Against those dangers as against others, the principle of the right to free speech is always the same. That is 100% true, right? Congress cannot just wave its hands and violate various provisions of the Constitution, even though with the strict scrutiny jurisprudence, there is at least some level of an ability for laws and Congress to do that if they can show compelling state interest, and national security is one of those. So it's accurate for TikTok to say this. It's also not the end of the story when you look at a lawsuit like this one. Now, TikTok's going to describe itself here, and one of the things it wants the court to know is that it's very, very American, right? And you can certainly understand why they want the court to know this. In the United States, the TikTok platform is provided by TikTok Inc., a California incorporated company that has its principal place of business in Culver City, California, and offices in New York, San Jose, Chicago, and Miami, among other locations. Every office has an American flag flying, Your Honor. Like many platforms owned by companies that operate globally, the global TikTok platform is supported not only by those employees, but also by employees of other ByteDance subsidiaries around the globe, including in Singapore, the United Kingdom, Brazil, Germany, South Africa, Australia, and, yes, Your Honor, China. Many of the global TikTok platform's functions are spread across different corporate entities and countries, and the global TikTok business is led by a leadership team based in Singapore and the United States. Like other U.S. companies, TikTok Inc. is governed by U.S. law. We're proud to be an American, or at least we know we're free, says TikTok. TikTok Inc.'s ultimate parent company is ByteDance Limited, a Cayman Islands incorporated equity holding company. ByteDance was founded in 2012 by Chinese entrepreneurs. Over time, the company sought funding to fuel growth, as is common in the technology sector, which resulted in the issuance of additional equity and dilution of existing shares. Today, approximately 58% of ByteDance Limited is owned by global institutional investors, such as BlackRock, General Atlantic, and Susquehanna International Group, some of which are names that we've seen in other contexts here in virtual legality, but are intended in this case to indicate that we are just another company like anyone else that has BlackRock as its primary shareholder, and we follow what they tell us to do. 21% is owned by the company's founder, a Chinese national who lives in Singapore, and 21% is owned by employees, including approximately 7,000 Americans. And that 21% number is important. We see in the statute that one of the things that divestiture requires is not to have 20% ownership of someone that has a jurisdictional connection to a nation that is an adversary of the United States. ByteDance launched in May 2017, is very popular. TikTok is very popular. Everybody loves TikTok. Petitioners' efforts to address the U.S. government's asserted concerns regarding the TikTok platform date back to 2019, when on August 6, 2020, President Trump abruptly issued an executive order purporting to ban TikTok under the International Emergency Economic Powers Act, or IEPA. Two separate district courts preliminarily enjoined the ban order, concluding, among other things, that it exceeded the president's IEPA authority. Specifically, as these courts correctly recognized, the president's IEPA authority to deal with any unusual and extraordinary threat to the nation does not include the authority to regulate or prohibit, directly or indirectly, any personal communication or the importation of or exportation of any information or informational materials to prevent the statute from running afoul of the First Amendment. Now, notably, that was an attempt by the president to use an executive order to ban or otherwise control the operations of a disfavored company. That is distinct from what's happening here, where Congress has passed, as David mentioned, overwhelmingly, a law to ban or otherwise curtail the operation of a disfavored company. So there is a stronger argument under the Constitution and the construction of the United States government that Congress can be allowed to do this over a president executive order, where presidents execute laws and don't otherwise create them. But because TikTok had a certain amount of success getting that ban order overturned, I think that's one of the reasons why we see that First Amendment argument premised so highly in their lawsuit here. So that's why we see them arguing so much over First Amendment concerns, where in this case, TikTok isn't the primary speaker on their platform, even if they are a speaker on their platform, right? We talk about this a lot in virtual legality, where TikTok can editorialize. The algorithm is doing a certain amount of speaking on behalf of the platform holder itself because it's picking what you see and hear. But for the most part, it's user-generated content. So one of the ways where I think this particular case could wind up looking stronger in the long term is if TikTok winds up bringing in some of the users to this lawsuit and saying their voices are particularly being curtailed, right? And you see this reference a lot. You'll see reference to 170 million American voices being silenced and things like that. But since they aren't parties to the lawsuit as it stands right now, I think their First Amendment argument is a little bit weaker than it could be. And then you have a history here of them dealing with various aspects of the U.S. government security apparatus. Between January 2021 and August 2022, petitioners and CFIUS engaged in an intensive fact-based process to develop a national security agreement that would resolve the U.S. government's concerns about whether Chinese authorities might be able to access U.S. user data or manipulate content on TikTok, as well as resolve the pending CFIUS dispute. During that time, petitioners and government officials communicated regularly, often several times a week, not 7 times a week. That's a lot. The result was an approximately 90-page draft national security agreement with detailed annexes embodying a comprehensive solution addressing the government's national security concerns. I would not have wanted to be a part of that negotiation process. That sounds like a bear. Notably, the draft national security agreement provided that all protected U.S. user data as defined in the agreement would be stored in the cloud environment of a U.S. government-approved partner, Oracle Corporation, which would allow review and vet the TikTok source code. And again, if you want to look at the real politic here, you see the U.S. favoring a U.S. government-approved partner in Oracle over the partly Chinese-owned TikTok, and you can have your own thoughts about the economics and policy decisions made there. But that's all happening behind the scenes, outside the purview of the Congress or the courts. From petitioners' perspective, all indications were that they were nearing a final agreement. After August 2022, however, CFIUS, without explanation, stopped engaging with petitioners in meaningful discussions about the national security agreement. In March 2023, without providing any justification for why the draft national security agreement was inadequate, CFIUS insisted that ByteDance would be required to divest the U.S. TikTok business. So they were talking with the U.S. government at some point in 2022, 2023. The U.S. government says, you know what, we're going to be able to ban you separately, and we're not going to talk to you about this anymore. And that's when all of this kind of proceeds to roll downhill at the congressional level. A divestiture that severs TikTok's U.S. operations from the rest of the globally integrated TikTok business is not commercially, technologically, or legally feasible. And we saw this discussed in the NPR article. But one of TikTok's primary arguments here is that qualified divestiture provision that we looked at in the statute isn't something that they can actually do within the 9 or 12-month period, and they have a number of reasons for that. First, a standalone US TikTok platform would not be commercially viable. A divestment of the US TikTok platform without any operational relationship with the remainder of the global platform would preclude the interoperability necessary to make international content seamlessly available in the US market and vice versa. As a result, the US TikTok platform would become an island where Americans would have an experience detached from the rest of the global platform and its over 1 billion users. Such a limited pool of content, in turn, would dramatically undermine the value and viability of the US TikTok business, which is the reality here as to why it's not viable, right? They don't want to sell for pennies on the dollar. And if TikTok US is pennies on the dollar and also a competitor to TikTok Global, they don't want to do it at all. Second, precipitously moving all TikTok source code development from ByteDance to a new TikTok owner would be impossible as a technological matter. The statute requires that all of the code be wrested from petitioners so that there is no operational relationship between ByteDance and the new US platform. Specifically, to comply with the law's divestiture requirement, the code base would have to be moved to a large alternative team of engineers, a team that does not exist and would have no understanding of the complex code necessary to run the platform. And that is true. There's a statement in the statute that says you can have no operational connection with ByteDance as part of the named parties in that statute. But to some extent, this argument doesn't hold water for me because it's not TikTok's problem. It is insofar as the buyer would be willing to spend much less if it has to put together an engineering team and figure out how to operate this platform afterwards. But assuming that that's okay, that the price agreed upon between the parties is acceptable, the fact that they have to do that doesn't actually impact ByteDance or TikTok in and of itself, right? The buyer has the problem, not the seller. Moreover, to keep the platform functioning, these engineers would need access to ByteDance software tools, which the Act prohibits. Now, that might be a longer-term issue, but again, I see this from a commercial transactions perspective as lowering the price of sale, not preventing it entirely, which brings us back to former Treasury Secretary Mnuchin and trying to purchase TikTok with or without the algorithm. Third, the Chinese government has made it clear that it would not permit a divestment of the recommendation engine that is a key to the success of TikTok in the United States. Like the United States, China regulates the export of certain technologies originating there, right? This isn't China being particularly weird as China. It's just like the United States and preventing technology from moving across its borders that it doesn't want to. So they prevent the removal of personal interactive data algorithms to non-Chinese companies, and that's going to be a problem from a logistical and political perspective for TikTok to actually consummate the sale. The Act bans TikTok and other ByteDance applications. The Act prohibits, on pain of draconian penalties, all these various things. The online mobile application store and internet hosting services from servicing foreign adversary-controlled applications. This is a statute that we read earlier, so I think we can mostly skip this section. But they do note here the various things that we noted above when we talked about the statute, which is to say that it applies specifically to ByteDance and TikTok. It doesn't apply to companies that don't have that presidential finding and the report to Congress. And it also doesn't apply to any company that, including its broad-based social media platform, also has a travel reviews specific platform. So there's a lot of problems that they have with all of this. They don't have any findings that TikTok or ByteDance are deserving of that particular call out in the statute. And so they find it to be unconstitutional and they ask the court to do the same. And I think I've skipped most of this section because it's mostly things that we've talked about before. It's a violation of the First Amendment. Congress shall make no law abridging the freedom of speech, which, as we've already spoken about, is the words in the Constitution and arguably should be more scrutinized than it actually is by American jurisprudence. But through strict scrutiny, they still allow the U.S. government to infringe on the freedom of speech if there is a compelling state interest, and the response to that compelling state interest is narrowly tailored to addressing the compelling state interest. So Congress has recognized the importance of protecting First Amendment rights, even when regulating in the interest of national security. For example, Congress repeatedly amended IEPA, which again is one of those areas where TikTok has specific understanding because President Trump tried to ban them under it, which grants the president broad authority to address national emergencies that pose unusual and extraordinary threats to the country. Accordingly, under IEPA, the president does not have the authority to even indirectly regulate personal communication, limitations that are necessary to prevent the statute from running afoul of the First Amendment. So they're trying to use essentially their prior legal research to make their case here, which is what you see in all parties, right? I have lots of clients where I talk to where you see their contracts or their vendor relationships and you see various weird provisions in those contracts and you say, this is a place where this party has gotten burned in the past, right? You learn from touching the hot stove and then you write it into your contracts. Here, They've been dealing with IEPA for 5 years, 5+ years at this point, and so they frame their arguments on the basis of what they know about IEPA. The Act's alternative to a ban, a so-called qualified divestiture, is illusory to the point of being no alternative at all. We saw their arguments there. The Act burdens TikTok's First Amendment rights, in addition to the free speech rights of millions of people throughout the United States, in 2 ways. First, TikTok has a First Amendment interest in its editorial and publishing activities on TikTok. TikTok is more than a passive receptacle or conduit for news, comment, and advertising of others. TikTok Inc.'s choice of material to recommend or forbid constitutes the exercise of editorial control and judgment that is protected by the First Amendment, and indeed is a place where they can potentially be liable for various things that they would otherwise highlight. And that's where the intersection between these kinds of cases and Communications Decency Act 230, which you might see referenced a lot in social media of all kinds, come into play. So they say, look, we're responsible for what we do on the platform. That is our speech through the operations of our algorithm. So we should be protected when they're looking to ban us on these grounds. As the government itself has acknowledged, when social media platforms decide which third-party content to present and how to present it, they engage in expressive activity protected by the First Amendment. Second, TikTok is among the speakers whose expression the Act prohibits. TikTok Inc. uses the TikTok platform to create and share its own content about issues and current events, including, for example, its support for small businesses, Earth Day, and literacy and education. Look at all these nice things we do as TikTok. When TikTok does so, it is engaging in core speech protected by the First Amendment. The Act precludes TikTok Inc. from expressing itself over that platform. Even if the U.S. TikTok platform could be divested, which it cannot for the reasons explained above, TikTok Inc.'s protected speech rights would still be burdened, because the Act appears to conclusively determine that any application operated by TikTok, a term that Congress presumably meant to include TikTok Inc., is a foreign adversary-controlled application. Section 2G3A, the president appears to lack the power to determine that TikTok Inc.'s-owned application is no longer being controlled by a foreign adversary and has no operational relationship with formerly affiliated entities that are controlled by a foreign adversary, right? There's no ability to get out of ByteDance and TikTok being named in the statute. The Act therefore appears to conclusively eliminate TikTok's ability to speak through its editorial and publishing activities and through its own account on the TikTok platform, which may or may not be true. It's a broad reading of the statute since it's supposed to only apply to the platforms that are operated by the company, but it is a plausible reading of the statute, and so I think TikTok is just throwing what it can at the wall with respect to the First Amendment. For similar reasons, the Act burdens the First Amendment rights of other ByteDance subsidiaries to reach their U.S. user audiences, since those companies are likewise prohibited from speaking and engaging in editorial activities on other ByteDance applications. The Act's restrictions on petitioners' First Amendment rights are subject to strict scrutiny for 3 independent reasons. First, the Act represents a content and viewpoint-based restriction on protected speech. The Act discriminates on a content basis because it exempts platforms whose primary purpose is to host specific types of content: product reviews, business reviews, or travel information and reviews. The Act thus distinguishes favored speech, speech concerning travel information and business reviews, from disfavored speech, all other types of speech, including particularly valuable speech like religious and political content. And here I think TikTok is exactly right? I think that this is a foot fault again in the statute itself. It rings to me of the kind of thing that comes out of lobbying. The term covered company does not include an entity that operates a website, desktop application, mobile application, or augmented or immersive technology application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. That somebody asked for this exclusion because they were worried they were going to get grabbed by this statute. But where First Amendment law says that you can control time, place, and manner, you can't control content, right? Like that's the stuff that gets the most scrutiny, the most strict scrutiny by the courts, is when you try to say, you can say red is good, but you can't say blue is good, or you can say blue is good, but you can't say red is good. That is the most obvious infringement of the freedom of speech, and that's why the courts disfavor it. If you were just sticking this to say, hey, if you're owned by China or North Korea or Russia, that's a kind of regulation focused on national security. That's one thing. When you add in, it will never include somebody that has an application that's mostly focused on travel information or business reviews. You're starting to favor specific content over other content. And I think TikTok is right there, and they're right to call it out in this particular area in their lawsuit. The Act also discriminates on a viewpoint basis because it appears to have been enacted, at least in part, because of concerns over the viewpoints expressed in videos posted on TikTok by users of the platform. For example, the House committee report asserted, without supporting evidence, that TikTok can be used by foreign adversaries to push misinformation, disinformation, and propaganda on the American public, a concern that in any event could be raised about any platform for user-generated content. Similarly, Representative Raja Krishnamurthy, sorry for the pronunciation there, Representative, who co-sponsored the act, expressed the unsubstantiated concern that the platform continued to show dramatic differences in content relative to other social media platforms. And this is a weaker argument, right? What Congress or individual Congress people say about the statute is not as strong of an argument as reading the words on the page of the statute and saying, as applied or foundationally, this is why this statute is a violation of the Constitution. You have to add in this extraneous information here, and the court might still be persuaded by it. There's nothing wrong with adding it, but it is a weaker argument than the words on the page. Second, the act discriminates between types of speakers. As explained above, TikTok Inc. is a protected First Amendment speaker with respect to the TikTok platform. The act facially discriminates between TikTok Inc. and other speakers depending on the primary purpose of the platforms they operate. Any application offered by petitioners is automatically deemed a foreign adversary-controlled application without any exclusions or exceptions. By contrast, any other company's application can be deemed a foreign adversary-controlled application only if the company does not operate a website or application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. The act favors speakers that do offer such websites or applications over speakers that do not. Moreover, the act singles out TikTok Inc. and other subsidiaries of ByteDance for unique disfavor in other ways. Whereas other companies with ownership in a country deemed a foreign adversary become subject to the act's restrictions only upon that presidential determination that the company poses a significant threat to the national security of the United States, ByteDance Limited and its subsidiaries are automatically subject to the act's draconian restrictions by fiat, or by being named specifically in the statute. The standard and process the act requires for every other company likely falls short of what is required by the First Amendment and other applicable constitutional protections anyway, right? The other group of companies probably also have a complaint here, but TikTok Inc. and ByteDance have been singled out for a dramatically different, even more clearly unconstitutional regime. With no public notice, no process for presidential determination that there is a national security threat, no justification of that determination by a public report and submission of evidence to Congress, and no judicial review for statutory and constitutional sufficiency based on the reasons set forth in the presidential determination that doesn't exist. The act also draws a speaker-based distinction insofar as it specifically names ByteDance and TikTok, and also exempts applications with fewer than 1 million monthly users, except if those applications are operated by ByteDance or TikTok. A statutory restriction targeting specific classes of speakers is subject to strict scrutiny, and that is especially true when, as here, the act singles out petitioners by name for uniquely disfavored treatment, and congressional statements indicate that the act targets petitioners in part because of concerns about the content on TikTok. Because the act targets both speakers and their messages for disfavored treatment, strict scrutiny review is required. In fact, we get into the Bill of Attainder kind of concept, right? Third, the act is subject to strict scrutiny as an unlawful prior restraint. The Supreme Court has consistently recognized in a long line of cases, this is accurate, that government actions that deny use of a forum in advance of actual expression or forbid the use of public places for plaintiffs to say what they wanted to say are prior restraints. Prior restraints on speech and publication are the most serious and the least tolerable infringement on First Amendment rights. The act suppresses speech in advance of its actual expression by prohibiting all U.S. TikTok users, including petitioner TikTok Inc., from communicating on the platform. And they have a number of various sites they have to defend that particular position. The same is true of other ByteDance subsidiaries and their platform. Then, so it's subject to strict scrutiny, they argue. It fails strict scrutiny because it does not further a compelling interest. Strict scrutiny requires the government to prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. If a less restrictive alternative would serve the government's purpose, the legislature must use that alternative. The act fails on both counts. The act does not further a compelling interest. To be sure, national security is a compelling interest, but the government must show how that act furthers that interest. To do so, the government must do more than simply posit the existence of the disease sought to be cured. Rather, it must demonstrate that the recited harms are real, not merely conjectural, and that the regulation will in fact alleviate these harms in a direct and material way. And Congress is going to get its chance if this lawsuit goes forward. Congress itself has offered nothing to suggest that the TikTok platform poses the types of risks to data security or the spread of foreign propaganda that conceivably justify the act. The act is devoid of any legislative findings, much less a demonstration of specific harms that TikTok supposedly poses in either respect. And here's where Congress would ordinarily not share classified information, but have recitals or whereas statements that appear in laws. You're probably familiar with these if you've read statutes at all, where essentially Congress says, whereas company X or company Y is very, very bad and doing very, very bad thing, and whereas we have the authority bestowed upon us by this prospect in the Constitution, and whereas we want to fix this, then we're going to pass this specific law. That doesn't appear in this act. It's not a requirement of the act, but this is what they're arguing in court. Congress has failed to do so far. So Congress will see if this proceeds, whether or not they have anything to actually claim against TikTok and ByteDance in the future. The statements of congressional committees and individual members of Congress during the hasty closed-door legislative process preceding the act's enactment confirm that there is at most speculation, not evidence, as the First Amendment requires. Instead of setting out evidence that TikTok is actually compromising Americans' data security by sharing it with the Chinese government or spreading pro-Chinese propaganda, the House committee report for an earlier version of the act relies repeatedly on speculation that TikTok could do those things. Speculative risk of harm is simply not enough when First Amendment values are at stake. These risks are even more speculative given the other ways that the Chinese government could advance those asserted interests using a variety of intelligence tools and commercial methods, which is an interesting thing to put in your lawsuit, right? So speculative risk doesn't count, but also China has way better ways than TikTok to go mess with your elections or what have you, United States. So this is ridiculous. The conjectural nature of these concerns are further underscored by President Biden's decision to continue to maintain a TikTok account for his presidential campaign, even after signing the act into law. Congressional supporters of the act have also maintained campaign accounts on TikTok. This continued use of TikTok by President Biden and members of Congress undermines the claim that the platform poses an actual threat to Americans. Further, even if the government could show that TikTok or another ByteDance application pushes misinformation, disinformation, and propaganda on the American public, the government would still lack a compelling interest in preventing Americans from hearing disfavored speech generated by TikTok users and shared on the platform just because the government considers it to be foreign propaganda. The act also offers no support for the idea that other applications operated by subsidiaries of ByteDance pose national security risks. Indeed, the legislative record contains no meaningful discussion of any ByteDance-owned application other than TikTok, let alone evidence proving that those other applications pose such risks. So they still, even with ByteDance named, claim that the statute is over-inclusive because ByteDance does other stuff. The act also provides neither support nor explanation for subjecting petitioners to statutory disqualification by legislative fiat, while providing every other platform and users of other platforms with a process that includes a statutory standard for disqualification, notice, a reasoned decision supported by evidence, and judicial review based on those specified reasons. Only petitioners are subjected to a regime that has no notice and no reasoned decision supported by evidence, opening the door to, among other things, post hoc arguments that may not have been a basis for the government action. And this is all Bill of Attainder stuff. The act also fails strict scrutiny because it is not narrowly tailored. Even where questions of allegedly urgent national security are concerned, the government must show that the evil that would result from the restricted speech is both great and certain and cannot be mitigated by less intrusive measures. To satisfy narrow tailoring, the act must represent the least restrictive means to further the government's asserted data security and propaganda interests, and be neither over nor under inclusive. The act fails in each of these respects. The act opts for a wholesale prohibition on petitioners offering online applications in lieu of a multitude of less restrictive measures it could have taken. As discussed above, petitioners have been involved in negotiations with CFIUS since 2019 over a package of measures that would resolve the government's concerns about data security and purported propaganda related to TikTok. The terms of that negotiated package are far less restrictive than an outright ban. The negotiations have resulted in the draft national security agreement, which TikTok Inc. is already in the process of voluntarily implementing to the extent it can do so without government action. That initiative includes a multi-billion-dollar effort to create a new TikTok US subsidiary devoted to protecting US user data and have US-based Oracle Corporation store protected US TikTok user data in the United States, run the TikTok recommendation system for US users, and inspect TikTok source code for security vulnerabilities. So it appears that the national security agreement that they've been working on for the past 5 years is a kind of quasi-divestiture into a separate US pillar, if you will, but does not separate out the global platform in its entirety because that's the overall product that TikTok is selling. If executed by the government, the national security agreement would also give CFIUS a shutdown option to suspend TikTok in the United States in response to a specified act of noncompliance. The government has never meaningfully explained why the national security agreement is insufficient to address its stated concerns about data security and propaganda. Even if the government's dissatisfaction with the draft national security agreement were valid, despite the government never explaining why the agreement that the government itself negotiated is unsatisfactory, the CFIUS process in which petitioners have participated in good faith is geared towards finding any number of other less restrictive alternatives to an outright total ban. It certainly seems like the act itself is not the most narrowly tailored way of answering the TikTok question, even if they do present a national security concern. Yet the government has not explained why the CFIUS process is not a viable alternative. There are also a wide range of other less restrictive measures that Congress could have enacted. While many of these measures are themselves unjustified as applied to petitioners, we did nothing wrong, Your Honor, they nevertheless illustrate that the act does not select the least restrictive means to further the national security goals that appear to have motivated it. For example, Congress could have addressed some member stated concern about TikTok allegedly tracking the locations of federal employees and contractors by expanding the existing ban of government-owned devices to cover personal devices of federal employees and contractors. Or Congress could have enacted legislation to regulate TikTok's access to certain features on users' devices, measures the Department of Homeland Security identified in 2020 as potential mitigations to reduce the national security risks associated with TikTok. Of course, Congress could also have decided not to single out a single speech platform and company and instead pursued any number of industry-wide regulations aimed at addressing the industry-wide issues of data security and content integrity. Congress could have enacted a data protection law governing transfers of American sensitive data to foreign countries, similar to the strategy President Biden is currently pursuing through executive order. Indeed, Congress did enact such a data transfer law, the similarly named Protecting Americans' Data from Foreign Adversaries Act of 2024, which we actually see as part of the same omnibus just below the TikTok ban, Protecting Americans' Data from Foreign Adversaries Act of 2024, which is a more broadly applicable provision about data security within the United States, right? So TikTok says you could have done any number of these things. A ban is way more than is necessary to control for the risk that is not true, Your Honor, but that could possibly be applied to our operation of our platform. There are also models of industry-wide regulation that Congress could have followed from other jurisdictions. For example, the European Union's Digital Services Act requires certain platforms to make disclosures about their content moderation policies and to provide regulators and researchers with access to their data so those researchers can assess if the platforms are systematically promoting or suppressing content with particular viewpoints. Congress pursued none of these. Congress did not even provide petitioners with the process and fact-finding protections that the act extends to all other companies, right? Getting back to we're not being treated the same as everyone else. The act is over-inclusive and under-inclusive. The act is under-inclusive because it ignores the many ways in which other companies, both foreign and domestic, can pose the same risks to data security and promotion of misinformation supposedly posed by petitioners. The government cannot claim that banning some types of foreign-owned applications is necessary to prevent espionage and propaganda, while at the same time allowing other types of platforms and applications that may create the same problem. Under-inclusiveness raises serious doubts about whether the government is in fact pursuing the interest it invokes, rather than disfavoring a particular speaker or viewpoint. Most glaringly, the act applies only to petitioners and certain other platforms that allow users to generate and view text, images, videos, real-time communications, or similar content. The act's coverage is thus triggered not by whether an application collects users' data, but whether it shows them content. Accordingly, there is no necessary relationship between the act's scope and Congress's apparent concern with risks to Americans' data security, which could equally be posed by personal finance, navigation, fitness, or many other types of applications. The act also singles out petitioners by exempting all other companies that operate any website or application whose primary purpose is to allow users to post product reviews, business reviews, or travel information reviews. But the act does not explain why such applications, when foreign adversary controlled under the act's broad definition and determined by the president to be a significant national security threat, could not likewise be used to collect data from Americans, such as Americans' location information, or to spread misinformation. Nor does the act explain why an entire company presents no threat simply because it operates a single website for the primary purpose to post product reviews, business reviews, or travel information and reviews. The act's differential treatment of this favored category of websites and applications also disregards the fact that there is voluminous content on TikTok containing product reviews, business reviews, and travel information and reviews. Yet TikTok and all ByteDance applications are ineligible for this exclusion. So that's basically their arguments here. I don't think they actually add anything more. At minimum, the act also fails intermediate scrutiny. If you don't apply strict scrutiny, there's another level. That's going to be a harder case for TikTok to make if they don't get the strict scrutiny finding. The act forecloses an entire medium of expression. It's overbroad constitutionally. And then it's a bill of attainder, as we talked about. It's an unconstitutional bill of attainder. You named ByteDance and TikTok. We talked about what a bill of attainder is. We talked about why that might be applicable. I think this is actually their stronger argument, but it's so rarely used in American jurisprudence that they made it their second argument, because First Amendment is a much more bright letter, protected by the courts kind of argument for them to make. And they also say it's a violation of equal protection for the same reason that would be a violation of the bill of attainder. It's the same kind of argument by treating people differently. Unconstitutional taking, you're stealing our stuff in violation of the Bill of Rights. We request that you give us a declaratory judgment that the act is unconstitutional, issue an order enjoining the Attorney General from enforcing the act, enter a judgment in favor of us. And hey, if you want to give us money, we're okay with that too. And that's the lawsuit. Folks, what do you think of all this? David, what do you think of all? Where did David go? David left. So I've been in the midst of talking about this lawsuit, and David has left us. I apologize for missing his departure. But that's me speaking on this. What do you think in the comments about this lawsuit? And we will get to those comments in just a minute. I want to make sure we grab everything that anybody might have said here in the background. I appreciate you walking through this lawsuit and this commentary with me. Aldo Hernandez has a question. Isn't our economy dependent on the same foreign adversary to make all of our products? You know, the nature of economics across international lines is very complicated. We've got tariffs going back and forth between these various countries. We've got things like this happening with bans and prohibitions on the various aspects of each other's economies. Whether or not that's a good thing is going to largely depend on your policy preferences for free market trade and free market economics, or protectionist policies to protect labor and other things within various jurisdictions. So we might disfavor China a little bit too much. We might not. It's really a matter of policy decisions by our Congress, but I'm okay with Congress being the ones to decide what the proper policy is, rather than the executive just making orders on these things. The question still remains, is it operating within the powers that Congress has? Against the Tide does tell us that David had a crazed client call. I'm sorry I missed him. This is what happens when I bring the screens up and I have to look through all my documents. I don't see the video share. So I apologize, David, that you had to go in the middle of all that. I was feeling bad that I did not prompt you in some of that, but when I got on a legal roll, I got on a legal roll. So I'm sorry about that. If you want to pop back in, you are more than welcome. And he is going to put that video up where we converse about this particular topic in a different way at some point in the next little while. So you're going to want to keep your eyes on his channel for that as we go along. Let's see here. Hello, darkness, my old friend. So we voluntarily watch things that we are allowed. Wonder what kind of personal information is on Tinder and OnlyFans. Where's the outrage over that? Well, I mean, I think, again, Congress has a certain concern about the Chinese ownership interests in ByteDance and TikTok. And you can think that's justified, or you cannot think that's justified, but that is distinct from some of the other companies that are operating within the United States borders. Leo also says, don't forget about Grindr. Sure. Yep. Keep it family friendly, folks. But yeah, we can just name internet properties and applications, certainly. Star says, I'm at least glad that we can have a discussion about this. I think it's a worthwhile discussion, right? I'm not somebody that uses TikTok, so I'm not sitting here saying that I think TikTok has particularly strong arguments because I want them to succeed on this. And I think, as David pointed out when he was here, Congress did overwhelmingly approve this act. So even when we identify things that might be wrong constitutionally, the Congress could go forward after it is overturned, if it is overturned, and write another law that addresses the problems that the court would identify in whatever decision that they made. So I'm in favor of that being the process. I'm certainly in favor of this discussion. I do think Congress went too far in naming ByteDance and naming TikTok, and then providing a content exemption for things like business reviews, which I would suspect was a function of quick action lobbying more than Congress specifically looking at that and saying these are things that need to be exempted. It doesn't make a ton of sense to me from the outside, but that's how mistakes are made, right? And Congress, even if they are high-level thinkers and elected by their fellow people, are still human beings that can make mistakes. Aldo asks, will the lawsuit go straight to the Supreme Court? Nope. It's being heard right now by the Court of Appeals. That's the court of exclusive jurisdiction for this particular answer. I think the DC Court of Appeals. Let me see if I can bring that up in the background here. Exclusive jurisdiction is the District of Columbia Circuit, United States Court of Appeals. So they have to go through at least one level of adjudication before they would hit the Supreme Court by nature of the statute itself. But it is the kind of thing that the Supreme Court could potentially take up. It's certainly a major action attempted by Congress, however you spin it. And so it's the kind of thing that the Supreme Court might well have an interest in pursuing. But as we know, the Supreme Court gets a lot of cases proposed to it and only accepts a very small amount. Leo says, in Congress, high IQ. I just mean to say that they are educated folks in general that have some notions about these things that maybe the average Twitter, TikTok, or other social media user doesn't, and yet they still make mistakes. Bet as a Hog says, hey, did you know there's an Amish dating app called Amish Match? I did not, Bet as a Hog. Thank you for bringing that to my attention. I'm not Amish, so I can't use that, but I'm also married, so I can't use that. But thank you very much. Leo says replace with AI, easy win. Replace Congress with AI. I mean, I think we're well on the way to Skynet when we replace our political institutions with artificial intelligence, right? To some extent, intelligence in political institutions is artificial as it stands, right? Okay. I guess it's tied. Not a question, but Mrs. Hoeg is awesome, is just accurate. So I wanted to bring that up again. She is fantastic. Okay, everybody. If you have any more questions or comments on this particular topic on TikTok, do you use TikTok? Do you like using TikTok? Do you find it to be presenting you with misinformation or disinformation at a greater clip than other social media sites that you might use? Do you feel like there's any kind of Chinese influence that you can ascertain using TikTok? I'd be interested in all of those things. I don't use it myself. I don't know. So let me know. I know a lot of people do use TikTok. I know a number of my law friends use TikTok, and I'd invited some of them to this episode, but I know that they are covering the Karen Reed trial right now. So if you are interested in that trial, you can go see Emily. You can go see Alita. You might be able to see other folks broadcasting that trial when this episode concludes. But I'm very thankful for everybody being in the space today, talking about TikTok, talking about social media, and whether or not Congress is acting within the authority given to it by we the people. So if you have any other questions or comments, let me know. Otherwise, I'm going to be wrapping up this video. Toot sweet. Thank you, everyone, for being here. Hello, Darkness, my old friend. Says TikTok takes up too many gigs to run. Maybe that's because they're running secret spy bots. No? Oh, okay. All right. Papa Rick, back on topic. I watch TikTok on YouTube and Twitter. I refuse to have a TikTok account. I do get a lot of TikTok videos floated to me on Twitter, right? When people pull them from that platform and bring them over. I don't use Twitter as much as I used to. I find it a little bit less helpful than it once was. But yeah, I hear you on my exposure to TikTok is basically limited to those kind of platforms. Yoshizu says China themselves banned TikTok. But China bans a lot of stuff. I'm not sure that is the rule that we should use in ostensibly a free society to decide these questions. China blocks it. It's good enough for us to block. Would be a bad road to go down, I think. Mrs. Hoeg Law says, I will not use my TikTok. My clients and market are not there, and I'm otherwise trying to separate from my tech social platforms, which is just a good idea. I think most of these social platforms can easily become a hell space that contributes to depression or anxiety or what have you. But they've still been useful in my profession and marketing in various other ways. So I approve Mrs. Hoeg Law. I will still use Twitter from time to time. Todd, it really feels like the U.S. government is targeting TikTok, but I wish U.S. would stick to one point. Do they not like it because national security or because of psychological issues for the youth? They have picked national security for this reason. The courts like that as a compelling state interest. In general, national security is one that the courts are willing to defer to policymakers' decisions on. So Congress frames it as a national security issue. TikTok frames it as a First Amendment issue. Those are some of the strongest things that a court will protect. And then the real fight is it a bill of attainder? Are you targeting these various companies for reasons that are outside your ability under the Constitution? And that'll be the kind of under the headline reality of the legal dispute between these parties. Papa says, thank you for the stream. Thank you for being here, Papa Rick. I really appreciate it. And thank you everyone else for being here as well. And as we said at the top of this video, best wishes to Shareen's family. You were a noted member of the community. We loved having you here, and we're very sorry to see you go. So thank you, everyone, for being here in Virtual Legality, and I will catch you on the next episode of whatever we do here on the YouTube channel.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.